Ladies and gentlemen, I welcome all to my channel. Today we are going to discuss about the important landmark judgment passed by our Supreme Court on 2nd January 2023 about senior citizens settlement made over their sons. When a senior citizen make a settlement or gift in favor of his son or daughter, and it stipulates a condition that the son should provide maintenance, should maintain him, and if so the gift or settlement is made with on such condition, and if the son fails or daughter fails to maintain the parents, in such circumstances, under Section 23 of the Senior Citizenship Act, Senior Citizen Protection Act, they can file a petition before the Tribunal, Senior Citizen Tribunal, to cancel the settlement or gift. This is the provision. Now, in the landmark judgment, they have interpreted the section and the act in such a way to give extraordinary protection privilege to the senior citizens. So in that case, what happens? The father made a gift of his property to the son, and the gift deed was registered. On the same day, the son also executed a promissory note promising the father that he will maintain him in case if he fails to maintain. In such circumstances, the father has the power to cancel the settlement deed. So the father filed a petition before the Senior Citizen Tribunal. As far as Tamil Nadu is concerned, our district collector is the senior, acting as performs the functions of the Senior Citizen Tribunal. So in this case, it's a case reported as in 2025 live law Supreme Court 3. The case is Urmila Dixit versus Sunil Saran Dixit. The judgment delivered on 2/1/2025. This January 2025. So what happened? The father made a settlement through properties to his son, and son executed a promissory note promising to maintain the father. So when the father produced the settlement deed and a promissory note, the tribunal passed an order and set aside the gift. Against the settlement, the son has challenged admitted the execution of the settlement, but he has disputed the promissory note, and he claimed that it's a forged note. He has not executed any such note. Anyhow, the tribunal has set aside the gift deed. As second judgment, an appeal was preferred to single judge of the High Court. The single judge also confirmed the tribunal's order. As seconds that they went to the division bench of the High Court. The division bench reversed the judgment of the single judge and said that Section 23 of the Senior Citizen Act is a standalone provision, and court has no power to transfer the personal property, like what the division bench has ruled. As second judgment, the matter was brought to the Supreme Court for its consideration. The Supreme Court not only reversed the division bench judgment, but also gave a wonderful meaning, wonderful interpretation to the act. It was held that Section 23 is a standalone provision. What is my standalone provision? As far as the Section 23 is concerned, the court has the power to, the tribunal has the power to cancel the settlement deed. So that alone is the power given, like what the argument was put up. But the Supreme Court, when interpreting the section, stated that when we are interpreting the section, you have to look into the statement of objects and the reasons of the act. So merely cancelling the settlement deed will not give the real fruit, real benefit to the senior citizen. Assuming that father executed a settlement deed and it is cancelled, and suppose the son is in the occupation of the property and he continues to enjoy the property, what is the benefit the son or senior citizen will get? So the court said, Supreme Court has said, so we have to look into the object, reasons, statement of object. This act was passed to protect the interest of the senior citizen. So the real benefit has to be given, without which it will be a mere waste of paper. So the court has interpreted the section in such a way that the tribunal has not only the power to cancel the settlement deed, the tribunal has the power to transfer the property and to order eviction of the occupants and to give the possession of the property to the senior citizen. Like what the judgment was, the Supreme Court has interpreted. Our Justice, Honorable Justice C.T. Ravikumar, Justice Sanjay Karul has given a wonderful explanation, wonderful interpretation, and they have derived a new law. Strictly speaking, explicitly the act did not empower the tribunal to order for eviction, to order for transfer of the possession, but our Supreme Court judges has interpreted the act in such a way that when we are looking into the object, statement of object, reasons, so the tribunal has power without which real benefit, the real object, real, real object cannot be achieved. So merely declaring their settlement deed null and void will not give any fruitful result to the senior citizen. So they have to get the property, they have to get the possession, if any occupants are there, eviction orders to pass, the senior citizen has to be put in the possession of the property, without which what is the use? So that is a very interesting judgment, very interesting interpretation. So in interpreting the judgment, they have followed the judgment passed in Vanitha case. Yes, Vanitha versus Deputy Commissioner of Bangalore. In this case, the court has held that tribunal has competency to order eviction and to hand over personal property, like what the tribunal, the court has observed. So the same principle is adopted and followed in this case, and stated that in the judgment it was held that though Section 23 of the stand is a standalone provision, Section 23 has to be interpreted in furtherance of the statement of objects and reasons of the act. So the tribunal has the power to order for eviction and to transfer the possession of the property under the act, like what our Supreme Court judges has interpreted the law and gave an extraordinary benefit, privilege, what is called it's a gift to the senior citizens. So in order to invoke Section 23 of the Act, the transfer must have been made subject to a condition that the transferor shall provide basic amenities and basic physical need to the transfer. So when we are making a settlement deed, whenever the senior citizen makes a settlement deed, you may put, it is always advisable to put a condition that the transferee, that is the beneficiary, so that your son or daughter, should give basic physical need and basic amenity to you. You put a condition. You being a senior citizen, you put a condition in your settlement deed or gift deed, say that you should maintain me and you should provide the basic amenities and a basic physical need to me. If you put such a condition and you fail to comply such condition, then you have the senior citizen has the power to file a petition under section 23 of the act and to cancel the settlement deed. Not only to cancel, you can also get an order for eviction in pursuance of the interpretation given under the judgment. It is really a benefit to senior citizen. So thanks to Supreme Court judges for giving a wonderful interpretation to the section and to the act. Ladies and gentlemen, you may watch my channels. Razyak's Law Tube is an English channel. Razyak Sattamari is a Tamil channel. There are a lot of videos. You may watch my videos and enrich your knowledge. Whenever you have a doubt, you can just type Razyak Sattamari or Razyak Law Tube and open our channel, and you can open our playlist and you open the relevant videos and enrich your knowledge. In addition to that, if you have any specific doubts, queries, clarification or legal opinion, you may contact this number. If time so permits, depending upon my time and availability, I will try to help you to give you online consultation or legal opinion. I will come again with another topic. Until then, goodbye. Razyak Ali.